Hello, everybody. My name is Maurice Button. I'm the CEO of City and Financial Global, and it's my great pleasure to welcome you to this, the next in our series of speaker interviews today. I have with me today Marcus Thompson, who's a partner at Kirkland & Ellis. Marcus is going to be speaking at our Economic Sanctions Summit 2024 on the 29th of January in central London. Marcus, welcome.
Thank you for inviting me.
Very good to have you with us. Let's turn to the first question. The Court of Appeal's comments in the recent Mintz case caused some controversy in relation to dealing with Russian entities. On 30th of November, the FCDO issued guidance on the subject, clarifying that there is no presumption in the UK's sanctions regulation that President Putin exercises indirect or de facto control over all entities in Russia. What advice would you give to companies in light of this?
So I think there's some legal advice and there's some practical advice. The legal advice is that what has now happened is that the Court of Appeal has confirmed what many of us, or all of us, frankly, just reading the legislation, always knew, which is that Regulation 7.4, given the breadth of its drafting, means potentially that any leader of a command economy such as Russia, who is himself or herself designated, potentially leads to the slightly ridiculous conclusion that every single company or business, public or private entity within that command economy is also subject to the same designation as the individual. That has been in the legislation since the regulations were passed. What the Court of Appeal has now confirmed is that that is in fact the conclusion one can and should draw from the plain words in the regulations. And what the Court of Appeal said was technically obiter. That means it wasn't part of the formal decision making that the court had to go through in that particular decision. But nevertheless, it's the Court of Appeal, it's a senior court. And so the legal position leaves us in a state of uncertainty and ambiguity, which is deeply unsatisfactory really for everybody. And also means that the UK sanctions regime looks, frankly, a little bit ridiculous and immature and unsophisticated. So none of those things are obviously good things. And I think the only very clear legal outcome of all this is going to be a change to the regulations. That's my view. And I don't think the FCDO guidance, although it helps a bit, I don't think it helps enough. So that's the legal analysis. The practical analysis, I think there are two things to say about that. One is, I think most people, albeit with a degree of caution, will carry on doing what they have been doing so far, which is that in the absence of clear evidence to the contrary, applying a reasonable amount of due diligence, will assume that unless an entity, a company, public or private entity in Russia, or indeed any other country within a command economy, is specifically designated, that just by virtue of the head of that economy being designated, that won't essentially infect everywhere else. But the level of diligence you'll have to do, it goes up, and the level of risk increases. And these are criminal offences if you breach sanctions laws, and there's now a civil strict liability test as well. So it leads to this very unsatisfactory state of uncertainty, which we've had to some extent we've had all along, but now it's just heightened. Practically, though, I think most people for the moment will carry on, but just gritting their teeth slightly more than they were before.
So I'm sure that's causing a fair amount of unease out there at the present time amongst companies. It's recently been revealed that over 100 companies have voluntarily admitted to being in breach of sanctions. What enforcement trends are you seeing? And what are the potential benefits and drawbacks of voluntary disclosure?
There's a little bit of a thread, I think, that runs through what we were talking about a moment ago with the Mintz decision and enforcement trends. And that, if I had to summarize it in one sentence, it is that the sanctions regime in the UK is immature and is still developing. The Mintz decision reflects that, because you've got the legislation saying one thing, Court of Appeal confirming that that's what it says, and the government rather hoping that it didn't say any of those things, and it will all work out in the end, but probably needing a change in the moment. And in the meantime, we're all in limbo. And I think the same is true for the enforcement landscape in the UK. If you compare it to the US, for example, where the enforcement landscape is just much more developed and sophisticated, and they've been doing it for longer. At the moment, Ofsi's track record on enforcement is limited, because Ofsi hasn't done very much enforcing at all, really, since its inception. Its recent track record does not inspire a huge amount of confidence, I have to say. Decision in a case involving a company called Wise, which was quite recent, where Wise allowed a payment of £250 taken out of a cash machine with a debit card, belonging to a designated person who was designated on the Friday. The account was frozen, but because the sanctions team at Wise didn't clear it until the Monday, 250 quid went out to an employee of the designated person. That was reported immediately by Wise. There was a delay over the weekend when the sanctions team weren't working, and obviously decided that on the sliding scale of lesser severity, moderate severity, higher severity, this was a case justifying moderate severity. And so although they didn't fine Wise, they named and shamed them using their so-called disclosure powers. And I think many sanctions lawyers and commentators, including me, were rather disappointed by that approach, because if £250 from a cash machine that was immediately, certainly within 48 hours, reported voluntarily, that's classified as moderate severity. One wonders really where the line is drawn for lesser severity, and where is the incentive in those circumstances to voluntarily self-report. So the enforcement track record, I think, is not fantastic so far. I'm sure it will improve, and I know a lot of focus is on enforcement at Ofsted and by government generally, because there needs to be a focus on it, because in order for the regime to develop and mature, there needs to be a proper enforcement approach and proper enforcement outcomes. The Wise decision was not wise, a poor pun, but that's where we are. So on voluntary reporting at the moment, I think it's still, again, rather uncertain landscape for people who are in that position.
One supplementary question, if I may. What are the lessons do you think that the UK sanctions regime might be able to learn from the US sanctions regime? You mentioned it's much more mature. Are there some broad lessons that we might learn?
Yes, I mean there are several. If I had to pick one or two, I think certainty of outcome and confidence that the authority, and in the case of the US OFAC, will act in a way that is predictable. That is a huge help. If you're a lawyer advising a company, or a board of a company deciding whether to self-report, knowing, or at least being fairly confident on what the outcome will be, is the first step. And in the case of Wise, I wasn't involved in that case at all, but you might reasonably think that the board of Wise, in making the decision very quickly, which they did to self-report, would assume that £250 reported as soon as possible within 48 hours would result in a lesser severity outcome. That would be a reasonable assumption, but it didn't. So the lack of certainty is, I think, one lesson, and perhaps a degree of sophistication on the part of the enforcement authority itself. Ofsted is an effective authority in many, many ways, and the people who work there are undoubtedly dedicated and serious people. There's no question about that, or their integrity. I think it's just a case of experience more than anything else. The OFAC regime has been around a lot longer. The authority has people working there who've been there a lot longer, and as Ofsted develops and matures, I'm sure it will get there too. It's just we're not there yet.
Okay. The war in Ukraine has slightly gone under the radar since the outbreak of hostilities in Gaza. Do you think the Gaza conflict will impact sanctions professionals? And where do you think the next area of focus for sanctions will be?
I don't think that the Gaza conflict will impact sanctions lawyers in the sense that, with regards to Russia or other regimes, for example, I mean, clearly what's happening as a result of Gaza is that the world's attention is now has something else to be focused on, and in terms of war equipment, whether it's artillery shells or the provision of intelligence and satellite coverage by the Americans and all the rest of it, that obviously has a new focus in the Middle East, which shifts things away from Ukraine. And in the media today, everyone knows that Congress is potentially heading for another shutdown in January, and unless the bill to approve more money for Ukraine goes through before Christmas, that will have a very material impact on Ukraine's ability to continue prosecuting the war with Russia. So I think that will have a much more profound impact on Ukraine. As far as sanctions are concerned, the relevant Hamas is already a prescribed terrorist organization here and elsewhere, so I don't think that necessarily the Gaza conflict will create more in the way of sanctions, but it will serve as a distraction to the rest of the world from what's happening in Ukraine. As far as what happens next in sanctions, I guess a couple of reflections. The most common question at the moment is China and Taiwan. If there is an escalation in hostilities between China and Taiwan, which a lot of people have talked about and anticipated to some extent, what will that mean? What will Western sanctions do as a reaction to that? That's a a long discussion, probably not for now, but that's certainly a question that people are asking. There is also a wider question about how effective sanctions are. So we're now 18 months, more than 18 months now after the invasion of Ukraine by Russia, and 18 months of, I think we've now had 11 EU sanctions packages and innumerable measures imposed by the US, by Canada, by Australia, by Switzerland, UK, sovereign countries with significant economic power imposing those sanctions on Russia. And there is a debate about how effective those sanctions are and what sanctions could be imposed and what impact they would have on Russia and what impact Russia's counter sanctions might have. So that's more of a sort of philosophical question about the efficacy of sanctions. But as far as regimes in the world where the issue might arise next, China and Taiwan is by far the most significant one that people are talking about. But because governments are now used to coming up with creative ways to implement sanctions as a result of what's happened in the last 18 months, I think we are likely to have more rather than less by way of sanctions regimes every time there is a conflict somewhere in the world, which the major economic powers do not want to deploy troops to mitigate or prevent, but they will try and deploy, they will try and learn lessons from what's happened with Russia and deploy similar sanctions regimes.
Yeah, so there's a great deal going on in this space, isn't there? And that's without even talking about Iran and others. Marcus, sadly, we've run out of time for this interview. So to our viewers, I very much hope you'll be able to join us at the conference, the Economic Sanctions Summit, on 29th of January in central London, to hear more discussion about these and other related issues. And it just remains for me to say thank you very much, Marcus, for your time today and for sharing those thoughts.
Thank you.